This is today the 16th day of January 2026, case number Regional Court 41/1164 of 2025. Appearance as before. The matter was remanded today for address by the state.
Good morning, Your Worship. I confirm my appearance on behalf of the accused. Before the state proceeds, I just need to please address the court. Your Worship, I want to bring an application to actually reopen the case based on new evidence of a video footage that we want to actually help this court with. This footage is actually from obviously third parties, and if you are given address the court on that basis, or rather for the court to order for the case to be reopened to enable us to make submissions, Worship, as court visits.
And if you say it's from the third parties, who are those people, and is it the reliable footage which we can say indeed is the one that is in possession of the state?
Your Worship, we do not have an idea whether that video footage is the one that is in possession of the state.
So how
But as far as we're concerned, that footage, Your Worship, is a reliable footage that is in possession of, I think it's Eyewitness News, which are well known as South African television and internet, what do you call it, service provider, or news provider. So, and taking into account that bail on its own is sui generis.
that I'm aware of, but now you just said you are not sure. I've asked you if is it the reliable one, and from where you said you are not sure. So I want to say to you, is it a reliable source, and is it the same as what the state heard?
Your Worship, we don't know what video footage the state has, since the court decided that particular video footage was not necessary for these proceedings. So now, as we have always maintained that this is a matter of public interest, in reopening the case, the court can actually look into evidence that is presented by a third party, as long as you show that that particular footage is relevant, is material, and is weighty to this case. And as far as I'm concerned, Worship, we don't necessarily have to deal with the basic requirements in terms of like normal court, trial proceedings. So in this instance, if the court is satisfied, we can hand it over just to satisfy the court on balance of probabilities, if there are exceptional circumstances and in the interest of justice that is accused be released, Worship, as court visits. In actual fact, Worship, I read somewhere where they said third-party video footage, just like hearsay evidence, can be accepted without meeting stricter admissibility requirements that are normally used for trial. Bail applications are unique judicial function with a lower standard of proof and fewer legal formalities. So, Your Worship, as far as you're concerned, this particular video is very relevant to this bail application, because there's issue of identity, there's issue of time as to when this time, what time this particular incident happened, and as to how many people are in this particular video footage at the time of the happening of the incident, and as to the visibility thereof in terms of this particular video footage. If the state has another video footage that is different from this, they're going to come and tell us. Remember, Your Worship, we need to be visionaries as the defense. What we're doing now, we are actually not only now looking into this bail application, we're already looking into the trial.
That I understand, but it seems you are fishing because of each and every time on the next step of postponement, you always have something new.
Your Worship, unfortunately...
When I was asking you during your application, you said you are done, you don't have any further evidence. And every day, you always bring something new.
Thank you. It's new evidence that was presented to me by a third party with a date of yesterday. Yesterday, I spent the whole afternoon at court. I only got to know of this late in the evening. It has a date of yesterday, late in the evening. And when I look at it, I'm like, this is relevant for a bail application. The court will have to make a determination. I'm at the mercy of the court in this regard.
But
this particular...
I don't want to interrupt you, but do you agree with me? On the first application, you brought your application, affidavit of the applicant, you close your case. The following day, while I was expecting the state to proceed, you said you are not done, you bring in address. Then we postpone, that is to corroborate your affidavit alibi. Today is another one.
But isn't it our right, Your Worship, to request or to bring an application to reopen the case at any stage before the court makes a judgment on the matter, as long as we give satisfactory and compelling reasons as to the court, to the court as to why should the court consider this footage. This footage is in the public eye. It's there for everyone to see. The state has failed to provide footage. We have the footage from a third party who is a reliable source, and we don't have to deal much with the admissibility issues. So to help the court to make an assessment, to have a look at that particular video footage, it's circulating, it's everywhere, it's there for everyone to see. Even a blind person can see in that particular video footage. So with due respect and humble stewardship, we request that such be considered. However, if that is not considered, we have already addressed the court on the exceptional circumstances on this matter. We'll be at the mercy of the court.
Inkantolo iyakuzwisisa ukuthi ngaso sonke isikhathi ngoba ke ukuvalile ufunda ke incwadi zakho. Ngakho-ke ngaso sonke isikhathi umuntu wakho unokusha azanakho kunzima waphendula. Manje-ke uyaziphendula kuyilungelo lakho ukuthi-ke le video footage nayo izawusiza efinyeleleni esinqumweni esifanele mayelana nesicelo sakho. Kanti-ke futhi uyachaza ukuthi kusemthethweni ukuthi-ke ngingavula ubufakazi bakho obusha ngaso noma kuningi eqaleni inkani nje inkantolo manje. Ngakho-ke uthi-ke yona lesitofo lesanaso-ke usithole kwabanye abantu kanti-ke sigcwele-ke layo emphakathini abantu abaninzi. Kodwa-ke uma inkantolo ingasamukeli isicelo sakhe, ngakho-ke akanankinga, kodwa-ke uzibekile-ke izizathu ey'khethekile ezihambisana naso nesicelo sakhe.
As the court pleases, Worship, state object to the request made by the defense. Number one, they've already closed their case. A well-experienced attorneys, before they start with their bail application, they may make sure that they investigate their case thorough, gather all the information. Before they can even start the bail application, gather all the information. So, in this one matter, my learned friend all the time, he closed the case all the time, supplementary affidavits, new evidence. And therefore, State requests the court to dismiss the request by the defense.
Umshushisi uyaphikisana nje nesicelo senu lesibeka lesithula uthi-ke okokuqala nivalile ngabafakazi ummeli onesipilio into ayenzayo-ke ukuthi-ke aqoqe bonke ubufakazi bakhe kube phambi kwakhe ngaphambi kokuthi aqale ukwenza ukufaka isicelo sebheli. Ngakho-ke uthi ngalezo zizathu ucela-ke inkantolo ingasamukeli isicelo sakhe.
And furthermore, Your Worship, he says that the state failed to produce a video footage. We didn't fail to produce a video footage. The video footage is at the lab. At this stage, it is not readily available. And furthermore, Your Worship, my learned colleague says that he is not sure whether the footage which he has, it is the same footage which the state have. So we are just going to deal with the thing which he is not sure. Thank you, Your Worship.
Uthi-ke okunye ngakuzelayo uthi ummeli utshela inkundla ukuthi bahlulekile bangabashushisi ukuthi balethe leyo video footage khona. Kodwa-ke uyacacisa ngoshushisi ukuthi cha, asihlulekile. Inkinga nje ukuthi-ke le video footage ile kobuchwepheshe ikhona. Kanti-ke futhi ummeli uke wachaza ukuthi akanaso isiqiniseko sokuthi leyo footage le afuna ukuyinikezela inkantolo ukuthi iyona le ephethe abashushisi. Uthi ngakho-ke ngoba anganaso leso siqiniseko, ngakho uyacela ukuthi cha, inkundla ingamnikezeli.
May I just reply briefly, Your Worship? I don't want to waste time on this. I must make it clear to my colleague, this matter is not about me. I'm an attorney. This matter is about the accused. This matter is about law. This matter is about evidence. This matter is about interest of justice. Interest of justice should be served. We must discern between witness opinion and state evidence. And understanding very well this is a bail application, we need to help this court in making a determination. It's not about me, it's about the law. The law allows me to reopen or to bring an application or a request for the defense case to be opened before the court can make a decision or judgment on the matter. Nothing stops me from doing that. It is only for this court to decide. The state is not going to suffer any prejudice whatsoever if this matter were to be reopened. With due respect, as the court pleases.
Lecala leli limayelana nawe nomthetho nkambiso. Ngakho-ke uthi-ke inkantolo mayibhekisise isicelo lesi akusisona sakhe, kodwa isicelo asifakele wena la enkundleni. Ngakho-ke uma ngabe-ke iyavunyeleka ukuthi alethe leso sicoco la enkundleni, inkundla nayo izokhona ukusizakala ekufinyeleleni esinqumeni esifanele. Ngoba-ke nani njengoba umuntu olenzizana ummeli wakho ninalo ilungelo lokuthi ningavula-ke isicelo sakho noma nesizini esibili noma esithathu. Kodwa-ke abashushisi bona abanazo kahle ukuthi uma ubufakazi lobo enkantolo isivuma ngesicelo senu ubufakazi faka futhi la enkundleni.
I'm going to take tea time adjournment at 12:30, then we'll deal with the application.
As the court pleases.
Sizawubuya ngemva kwenkundla ezobuya nesibili.
his name? Oh, there, Fafana is here. Fana, can you assist me, Mr. Nkendiso, to place on record? Thank you. Thank you. We are back on record after I took an adjournment shortly. And before I adjourn, Mr. Mabunda have just addressed me that he wants to reopen his case and he's got new evidence regarding the video footage of the scene. I've asked him if ever it is the same video footage which is in possession of the state, and he said he's not sure. And he said that the said video footage is coming from the third party social media. And as of now, as we are here in court, is actually circulating out there. And at this stage, I can't say much about that footage, and especially that the authenticity of this video footage and how reliable it is. And what I'm going to say now, I'm not saying that's how it is, but it is possible. Most of the video footages that are circulating on social media, they may be amended, tempered, or edited of some sort. Because of we don't know who is this author of this footage, where was it obtained, and is it a relevant source, reliable one? But because of it's the defense and the applicant who want to present to the court, they have the right to do so, and I'll give them that opportunity to present it to the court. And I want to warn Mr. Mabunda and the applicant that as this video footage is now going to be admitted before this court, the state may use it against the applicant at a later stage during the trial.
This court is
so this video footage that is going to be presented, I cannot say it is the same as of the state. It comes from the defense. And again, I don't know how Mr. Mabunda is going to present this evidence of the video footage before this court.
Manje anginalo ulwazi lokuthi-ke umnumzane uMabunda uyonikezela kanjani ngaso leso sicofo.
Proceed, Mr. Mabunda.
Thank you. Let me highlight first, Worship, we're not saying that it is it or it is not it. We are saying it is there and that we're presenting it so that it can be able to help the court in making an assessment. Worship, we have downloaded same on a stick. However, I have it on my phone. If the court is amenable to, I'm willing to play it and hand over the footage, the record on my phone to the court to view same and for the state to view same. Alternatively, we can use help here with a gadget to be able to.
It's better with that.
Can you please be able to help us?
And that's for recording purposes.
I apologize, Worship, it's for recording purposes.
Okay.
So I don't know, I was trying to actually open it through my laptop, but to no success. If we can get someone who would assist us with viewing of this footage. I'm not too sure whoever has a laptop for the court to assist us in viewing the footage. A colleague of mine is assisting us in that application.
Uthi-ke ummeli akanalo ulwazi lokuthi yiso leso sicofo bana sameshusiseka nje kodwa-ke lesicofo lesi-ke unaso kanti-ke sikhona namakhalekhikhini wakhe. Ngakho-ke uthi akazi ukuthi anikeze inkantolo umakhalekhikhini wakhe noma yenze njani ngoba uthi unaso i-memoristic lesicofo lesi. Manje kujamile ukuvula kwisixophamazi sakhe kodwa-ke asivuleki. Manje-ke ummeli lo ola enkundleni-ke nesicofo sakhe-ke ngizama ukusiza ukuthi inkantolo ikwazi ukusibona.
Thank you so much, Oshi. I'm not too sure if I should place it this way so that the court can be able to view or to hand it over to the court to view it at a closer range.
It's too far from me.
And I might just believe to hand over same to the court. The court will just press play and then view the footage as the court pleases. And thank you for accommodating us in that regard.
Unikezela-ke inkantolo-ke isixophamazi ukuthi-ke sisibone ngoba engathi sibonisa inkantolo la khona kodwa inkantolo-ke yaphawula ukuthi cha ukude kakhulu amayikhomoto manje-ke unikezela inkantolo.
Okay, it's on the lab book note, and what is here, it's a 15 January 2026 CCTV footage showed two men, one believed to be a gunman and the other his accomplice, alleged involved in the shooting of Warrick Stock, aka DJ Warras, on the 16th of December in Johannesburg CBD. And it's got TikTok logo, it's got at News Spectrum. So actually
The footage supplied to EWN shows two men, one believed to be the gunman and the other his accomplice, allegedly involved in the shooting of Warrick Stock, aka DJ Warras, on December 16th in Joburg CBD. At 16 minutes after 12, Stock is seen in a black t-shirt, accompanied by an unidentified man on his left in a white t-shirt. Stock has just exited Zambezi House, a hijacked building on Van Wielich Street in Marshalltown. Stock was there to assist contractors who were installing a biometric system in the foyer of the building. The pair walked out of the shot towards Fox Street. According to testimony by the investigating officer, Stock briefly stepped into a vehicle he was using on the day, an Audi Q7, which is parked just a few meters away near some street vendors. Out of shot in this footage, evidenced by the IO, says Stock opens the passenger side door, gets into the vehicle while having a conversation on his cell phone before closing the vehicle and locking it. He then starts making his way back to Zambezi House. It's about 54 seconds since Stock is seen exiting Zambezi House, now 17 minutes past 12, when we see people frantically ducking for cover. In the commotion, we see the alleged shooter in the crowd. Stock was shot 5 times. The alleged gunman is dressed in a green t-shirt, blue floral shorts, sandals, and a cap. The shooter then doubles back and picks up something from the ground, possibly the keys of the Audi Q7 that Stock was using, as the keys were never found, before he calmly walks towards Fox Street. From another angle, we see another suspect picking up 2 bags near the informal street vendor stalls. The Audi Q7 is parked just out of shot. One of the 2 bags is a dark yellow gift bag. EWN understands the gun used to kill Stock was concealed in this gift bag. The main shooter was captured earlier, flagged by his accomplice carrying the same bag. The shooter then quickly follows his accomplice as the pair make their way towards Fox Street. Captured.
Thank you.
Thank you so much.
I'll give
May I
it to
just say,
Mr.
for the
Majola.
present same, we are not going to the state for their benefit to look at it as well, Lordship.
CCTV
The court business.
slides EWN shows 2 men, one believed to be the gunman and the other his accomplice, allegedly involved in the shooting of Warrick Stock, aka DJ Warras, on December 16th in Johannesburg CBD. At 16 minutes after 12, Stock is seen in a black t-shirt, accompanied by an unidentified man on his left in a white t-shirt. Stock has just exited Zambezi House, a hijacked building on Warrick Street in Marshalltown. Stock was there to assist contractors who were installing a biometric system in the foyer of the building. The pair walked out of the shot towards Fox Street. According to testimony by the investigating officer, Stock briefly stepped into a vehicle he was using on the day, an Audi Q7, which is parked just a few meters away near some street vendors. Out of shot in this footage, evidenced by the IO, says Stock opens the passenger side door, gets into the vehicle while having a conversation on his cell phone before closing the vehicle and locking it. He then starts making his way back to Zambezi House. It's about 54 seconds since Stock is seen exiting Zambezi House, now 17 minutes past 12, when we see people frantically ducking for cover. In the commotion, we see the alleged shooter in the crowd. Stock was shot 5 times. The alleged gunman is dressed in a green t-shirt, blue floral shorts, sandals, and a cap. The shooter then doubles back and picks up something from the ground, possibly the keys of the Audi Q7 that Stock was using, as the keys were never found, before he calmly walks towards Fox Street. From another angle, we see another suspect picking up 2 bags near the informal street vendor stalls. The Audi Q7 is parked just out of shot. One of the 2 bags is a dark yellow gift bag. EWN understands the gun used to kill Stock was concealed in this gift bag. The main shooter was captured earlier, flagged by his accomplice carrying the same bag. The shooter then quickly follows his accomplice as the pair make their way towards Fox Street. Captured.
Your Worship, further, I have zoomed in pictures of the very same individual that I want to present to the court. The reason I want to present these zoomed in pictures of the same individuals in this is that in his bail application, the applicant indicated that when he was arrested and assaulted, he was shown pictures and he was asked if he know those people. And these are the very same people. And he told the police he doesn't know them. So these are the very same people that he was asked about. So we'll zoom it on, we'll hand it over to the court to view it as well to satisfy the court and the state. Then we can proceed. Thank you so much.
Uyaphinda futhi uyangezelela ukuthi kuney'thombe ezimakhalekhukhwini wakhe nazo ufuna ukuyenza nazo
closed.
Thank you so much. May I request to be on it?
Well,
I can actually give my colleague my phone. You can just look into it. And I appreciate the assistance of colleague. That is the only aspect actually. Are you satisfied?
okay, Mr.
Thank you so
Mabunda,
much.
how many photos do you have there?
How many photos?
Okay, can't you print them out?
I printed, but unfortunately they're in black and white. I didn't print in color. That's the unfortunate part.
So that's the only,
That's the
Photo
only
that-
one. In actual fact, that's the only one. They just zoom it in.
and that is what you want to show to the court now from that
Yeah,
laptop?
it's the same actually.
Oh, okay.
And that's all the shit. So,
So
okay.
it's fine. The video footage, I will admit it as exhibit 1.
Thank you so
And
much.
the photo, it will be exhibit E.
Thank you so much, Yoshi.
Kanti-ke lesasitofo ukantozo samukela nje what is kanti-ke isithombe ngesizo.
So, Your Worship, our reason for wanting to hand over that particular footage was to establish the following.
Just for a second, Mr. Majola, you managed to view it here?
Yes, Worship, I did.
Okay, fine.
Yes.
We wanted to establish the following, that on this footage that was handed over to the court, the report says that now the incident happened at about 16 minutes past 12 or 17 minutes past 12
Which report are you referring to?
on the footage.
I did not see the time there.
Pardon, Your Worship?
I did not see the time.
Yes, the time is not there. I'm just highlighting to the court in terms of the report.
The
But-
reporter,
Yeah, by the reporter.
but it's not in the video footage.
Thank you so much, Worship. And then further to that, I just want to highlight further by the reporter that now the court has
Just
already
for a second,
accepted.
just for a second. From the reporter, you say the time is
It's 12:16
12:16.
or 12:17, somewhere around about there, because the deceased went out and spent some time in the car and went back.
And you agree with the court that there is no time on that video footage?
As far as I'm concerned, the time is not showing. Safe to say the report says so, Yoshi.
Mm.
Remember, Yoshi, we're presenting evidence by a third party that could be able to assist the court in this regard. And further to that, Yoshi, this time that the reporter is talking about, as much as this video footage doesn't show time, the court has already accepted Exhibit E as evidence, which is an alibi to say that now the accused was in Soweto at that time. And further to that, Your Worship, besides the issue of what the reporter says, looking into the footage itself, it is not clearly visible as to who's who in the zoo. And further to that, this report indicates that the shooter in this incident is the gentleman who's wearing a green t-shirt and blue floral shorts and a cap. And that now, that firearm that he had in his possession, it was eventually put in a bag when they walked away with his accomplice. And in this court, we were made to believe, or we're told, or there's evidence rather, that the shooter had dreadlocks. And when you look into that particular footage, it doesn't show anyone with dreadlocks. It shows someone who's alleged to be the shooter wearing a cap with no dreadlocks. And in the zoomed pictures now, the court must listen clearly. The pictures of these individuals in the video footage
The one that you
are the very same pictures that the accused said in his bail affidavit that I was shown those pictures and asked if I know those people. And remember, Oship, he said this long before we could even acquire this particular video footage. By God's grace, the video footage, for some reason, it came, and here we are, we're having it presented before the court. The court will have to make a determination on that. And he said, I do not know them. Oh, thank you. I'm sorry, sir.
Yes, the court is yours. Numza, umbeli-ke umesekhuluma-ke kabanzi enaba ngale video footage ekukhulunywa ngayo ekenikezele enkantolo-ke namhlanje uyacacisa-ke ukuthi-ke lo umbiki wey'ndaba uyacacisa-ke ukuthi-ke le sehlakalo sayenzakala ngabo-16 minutes emva ka-12 noma 17 minutes kanti-ke kubonakala abalisa ababili kuleyo video footage naye nomqophi wendaba ukhuluma ngabantu abalisa ababili kanti-ke lo okusolakala ukuthi nguye wadubula umufi wayefake-ke isikipha esihlaza kanti nebhruku elifishayo kanti-ke futhi-ke uma babona ukuthi-ke wadubula emhlanje umufi wase-ke leso sibhamu wayisebenzisa lesafakwa-ke esikhwameni base bayahamba-ke babheke eFoster kanti-ke uma-ke wena-ke usuboshwa-ke yinto enye futhi oyishilo esiceleni sakho sebheyili ukuthi wena amaphoyisa akubonisa isithombe salabantu ababili base bathi kuwe ngabe uyabazi ingabalisa kanti-ke wena wabatshela ukuthi cha awubazi ngakho-ke inkantolo ihamisa kancane ukuthi ngazi umushele ngoba uyakhohlwa umlilo wakho kumele umushele.
Thank you, my Presidency. So those particular pictures zoomed and looking into them, as I've highlighted already, there's no one with dreadlocks. And looking into them, there is no one who looks like this accused in any way whatsoever. I'm not an expert, but by naked human eye, there's no one that looks like this accused. Remember, these are the pictures that were shown to him. Yeah, thank you.
Uthi-ke uma-ke sezidonsiwe-ke le y'thombe zalabantu laba akekho-ke umuntu ofana nawe kulabalisa ababili ngakho-ke yinto-ke futhi oyishilo-ke esiceleni sakho ukuthi wena ubungekho la kanti ley'thombe lezi wena waboniswa sona amaphoyisa bakubuza ukuthi ngabe uyabazi.
Your Worship, unlike the state, the mighty state, with all the resources in the world, with all the expertise in the world, and experts in the world, and with all the time in the world, they cannot help this court with anything whatsoever. Here comes the defense with limited resources. The least we could do to assist this court in making a determination is to present this video footage. And we are saying to the court, and humbly so, please, Your Worship, look into that in making a determination.
Let's go for this. Siyosiza inkundla ukufinyeleleni esinqumeni
When the issue of the video footage was brought to the accused's attention when I went to consult with him, he was so excited that Mr. Mabunda, as in bayangisukela labo bantu. Yazi lento issue usebu hiyo ngo, meaning that They're taking chances.
Mr. Majola will
Oh, thank you.
interpret for me.
Uthi-ke mnumzane-ke kanti sonke lesikhathi lesi-ke uzile-ke lapho azokubonisa lesicofo wase-ke wena wamtshela ukuthi-ke uyazi sonke lesikhathi labantu bayakusukela ngakho-ke yiyo ngqo lento eshiwo what is the name?
Eusebio, Exhibit E.
Savior.
Eusebio. What?
Yeah.
Mr.
Yiyo
Majola, just one
yiyo
second regarding the exhibit.
What's his name? His name is Eusebio.
Before we proceed, I just want to rectify the issue of the exhibit. Yesterday, the statement of the alibi defense witness, it's exhibit E. And video footage exhibit 1. The one of the photo is exhibit F. I hope you got it right.
The alibi, what exhibit number is it? It means I missed.
Yesterday,
Yes.
you presented an alibi defense witness statement.
That's correct.
That is E.
Or E, that's the one I'm referring to.
Yes. And then F is this one of today.
That is correct.
The video footage is 1.
Thank you so much, Oshi. That's correct. That's correct.
iviyo footage-ke isitopho-ke lesiyana ezibikwa kanti-ke le statement-ke lesi esiyenziwe uSeviwe exhibit E le isithombe lezi ezinikezwe-ke inkundla exhibit F.
Okay, repeat from what you were saying about accused being excited about when
The
he was
footage?
shown. Listen, Mr. Majola.
Apologies, Oshi.
I'm still now addressing Mr. Majola.
Thank you so much.
He haven't interpreted all.
Thank you.
Lordship, may the court ask Mr. Mabunda to repeat that statement in order for me to interpret it
You
correctly?
said after you shown the accused applicant the photos or whatever, he was excited and he said something in Zulu.
That's
So it's
correct.
not yet interpreted.
Oh, thank you.
Translated by Mr. Mavuso to the court in English.
In English. Bangisukela labo bantu.
In fact, Lordship, I don't believe in the first myself. In fact, they are just putting the cart before the horse.
And he further said, yazi uyabona lento issue Eusebio, which is exhibit E. He
You
or no?
know what Eusebio said, which is exhibit E. That is true and correct.
Thank you. Just want to finalize. I don't want to waste more time on this. So he was excited. That-
Ujabulile kakhulu uma ubona le story.
All these things are going to vindicate him. In actual fact, he's happy. Never mind what this court decides. He's happy for trial purposes. He's going to present sufficient evidence in relation to this to vindicate him on this matter.
Ke noma ke isinqumo singathathwa yile nkundla singabanjani kodwa wena ujatshuliswe ukuthi leso lesicofo lesikhona kanti-ke kunobufakazi obuzoyenza-ke ukuthi cala lingakulazi.
All we're saying, Your Ship, is that we request this court to discern justice from chaos. The state has got problems with this matter. I don't even understand why this matter was placed in the first place. Those must have more submissions and last submissions before the court. Thank you, Your Ship.
Ngiyacela kakhulu ukuthi inkundla isebenzise isilungiswa kakhulu.
In actual fact, Mr. Macho just reminded me of something. Your Ship, in actual fact, I also want to highlight in a recent case law, in the case of, it's a well-known case, of Katisa Mulefe versus S on appeal. I think it was held on the 5th of November, 2025. It's reported under A64/20/2025, ZAGP, JHC, 1118. Where these accused, in actual fact, it's interesting. Katisa Mulefe is facing, amongst others, similar counts that this accused is facing: premeditated murder, conspiracy to commit crime.
Kanti-ke ngizothanda-ke ukucofa ngelinye lamacala La bekushushiswa khona ke uKatiso Mlilo nge-5 zikaNovemba 2025 enkantolo ephakeme yala eGauteng. La-ke uKatiso Mlilo-ke ubhekane namacala wokwakha itulo lokubulala kanti-ke futhi nokwakha-ke ukuhlela ukubulala.
It was held on appeal by the judge that the state, or rather the state's case, is based on speculative and insufficient evidence. There is no objective evidence.
Umahluleli-ke kulolu cala-ke umanje watshela-ke inkundla ukuthi-ke abashushisi-ke bayacabangela kanti-ke bayoba nenkinga ekuqhubekeni kwale cala ngenxa yobufakazi.
In Kasu, we're faced with the same thing, where I even said to the court, we must differentiate between witness opinion and facts and evidence.
Uthi-ke kuyafana-ke lokhu kwakatiso Mlilo necala lakho ngoba uyawacacisa enkundleni wathi-ke inkundla kumele ikwazi ukuhlukanisa-ke lokhu okushiwoyo nabantu nobufakazi obukhona.
In the Katiso Mlilo case, it's even worse, wherein there was even evidence of communications and payments and all of it. In this case, there's nothing. We only have car papers.
Icala likaKatiso Mlilo lona-ke lidlulele ngoba kunalabo kutomele khona-ke ubufakazi obuphathekayo bokubhadalana nento eyiningi. Kodwa kule cala la akukho konke.
So the judge eventually decided that the state has failed to place facts that have a stronger case, whether for conspiracy to order the hit and whether for the attempt at a premeditated murder itself. And same applies in Kasu.
Kanti-ke into-ke eshiwe ijaji-ke leyo yokuthi-ke abashushisi bahlulekile ukubonisa-ke ukuthi-ke yena kuKatiso wenza itulo lokubulala okanye-ke futhi wahlela nokubulala ngoba-ke bona-ke ubufakazi abanabo abuqinile kakhulu.
Bail lordship is to ensure that accused attends court,
Isicelo sebheyili okanye ibheyili yona ngokwayo
not as a punishment.
uqinisekisa ukuthi-ke wena-ke uyalihamba icala lize lifike emaphethini kodwa akusisona-ke isijeziso.
Are these not exceptional circumstances enough? The clear answer is in the affirmative. We have proven exceptional circumstances before this court.
Kanti-ke lokhu-ke akusiwona-ke izathu ey'khethekile kanti-ke kunjalo ukubekile sibonisile enkundleni ukuthi-ke kunezathu ey'khethekile esiceleni sabo.
One of the elements of the crime of premeditated murder is intent. Intention to kill. As the state, I understand that this is not trial, but with the evidence that has been presented before the court already, is there any evidence of intention? No.
Uthi-ke into enkulu ecaleni-ke lokuhlela ukubulala inhloso yokubulala. Ngakho-ke ngakule cala lakho ngabe ikhona-ke inhloso uthi cha ayikho.
Is there any evidence of prior planning? Is there something tangible, constructive?
Ngabe khona-ke bekuhleliwe ngaphambilini, ngabe khona yini into ephathekayo abanayo.
Thank you so much. No further submissions, Worship.
Sengiqedile angisenawo amaningi.
And according to the evidence which is on record, those people were seated there for 45 minutes.
Kanti ke ngokufakazi ke esinabo ke la enkundleni ke ukuthi ke labantu laba ke bebahleli lapho imzuzu engaba 45.
I don't want to dwell much on Mary's worship because the video issue is a trial matter.
Angifuni ukukhuluma kakhulu mayelana neqofo ngoba le ndaba yesitofo yokuxoxwa ngayo kanti kuyokhulunywa ngayo kabanzi uma iphakaseqhubu.
At this moment, we are busy with the bail application.
Okwamanje senza isicelo sebheyili.
Thank you, Worship.
Proceed with your submission.
As the court pleases, Worship. Your Worship, state requests the court, Worship, to refuse bail for the accused persons in this matter, based on the following reasons, Worship.
Thina ke njengabashushisi sicela ke inkantolo ingasamukeli isicelo sakho kanti ke igxile kulezathu ezilandelayo.
This is a Schedule 6 offense, Worship.
Okokuqala icala lakho libi kakhulu esigabeni sesithupha ngakho ke njengoba sengixhasile ngibonisa ukuthi ke kuyahambisana nokulungiswa kanti ke futhi kunezathu ezikhethekile ekumele ke inkantolo izibhekisise uma ibhekisisa isicelo sakho okubhekisisa isicelo sakho sebheyili.
The accused in this one matter is facing the charge of murder and premeditated murder.
Kanti ke wena ke la kulecala ubhekane necala lokubulala neleli lokuhlela ukubulala.
Hence, it is a Schedule 6. The onus of the burden is on the defense.
Njengoba sisesigabeni sesithupha konke kusemandleni ethu.
So in terms of section 60, 1A,
Kanti ke uma sikhuluma ngo-section 61A encwadini zomthetho,
of the Criminal Procedure Act,
incwadi yomthetho wamacala,
it says that the applicant has to show that there is exceptional circumstances which exist.
ukuthi kuyachaza ke ukuthi ke umuntu ofaka isicelo kumele abonise ukuthi kunezathu ezikhethekile kanti ke futhi ezikhona
That the interest of justice permit his release on bail.
ukuthi ke iy'ncomo kanye ke ubulungisa kuyahambisana nokuthi ke wena-ke ukhululwe ngebheyili.
Yeah. Firstly, I will highlight the difference between the bail proceedings and the trial proceedings.
Okokuqala ngizothanda ukuhlukanisa phakathi uma kufakwa isicelo sebheyili noma icala likhulu.
The reason why I want to highlight this is because I want to lecture my little colleague.
Isizathu sokuthi ke ngibeke lokhu phambi kwenkundla ukuthi ke ngifuna ukufaka ke ummeli wakho esikolweni
To educate my little colleague.
ngimfundise umfowethu.
During the bail proceedings,
Uma kwenziwa isicelo sebheyili
the focus is on section 60 of the Criminal Procedure Act.
kanti ke sigxila kakhulu ku-section 60 kwencwadi zomthetho.
And the onus still on the defense to prove on the balance of probability that they should be released on bail.
Kanti ke into emele yenziwa ummeli ukuthi ke kumele abonise ngaphandle kokungabazi enkundleni ukuthi ngempela zikhona izizathu ezikhethekile ezigoqelela inkantolo ukuthi ngakhulula ngebheyili uma kuqhathaniswa zonke izinto.
During the trial proceedings, it is us, the state, who has a burden to prove our case beyond reasonable doubt.
Kanti ke uma sesiqula ke icala umthwalo ke sokungowethu thina abashushisi ukuthi sibonise enkundleni ngaphandle kokungabazi ukuthi loyo muntu esuke secaleni unecala.
In this one matter, Your Worship, my little colleague dwelled much
Kulecala ke le. Hayi ummeli wakho unabile.
He dwelled much on the merits of the matter.
Unabe kakhulu kanti ke esizideni okanye kwingqikithi yecala.
Number one, he mentioned the fact that the state, we are relying on a single witness.
Oqala uthethina ke icala lethu sinofaka icaleni lethu sinofakazi oyedwa.
He further said that the court can still convict an accused person based on the evidence of a single witness if that evidence it is satisfactory in all material aspects.
Kanti ke uyaqhubeka futhi ukuthi uyawathi ke futhi inkantolo isengathola enecala ngofakazi oyedwa uma lobo bufakazi lobo bungculisile banelisa inkantolo kuzo zonke idingo zakhona.
That line of argument is a trial matter.
Lokakushilo lo uma ethula izethulo zakhe indaba esikhulunywa ecaleni uma seqhubeka.
Furthermore, my learned colleague disputed the formalities of the identity parade. He says that they were flawed.
Okwesibili uphikise indaba ke yekhomba ke le ID parade ngokulela kakhulu ukuthi ke hayi into eyenzakale lapha bengalungile.
The issue of the formalities of identity parade is the issue of a trial matter where admissibility has to be proven.
Kanti ke uma sikhuluma ngekhomba ke lokho kukhulunywa kakhulu uma icala ke liqulwa ngoba kumele ke ubhekisiswe ukuthi ke ngabe lokho bufakazi lokho buyamukeleka yini enkundleni.
In order to prove the formalities of identity parade,
Masi bekisisa kabanzi ukwenzeka kwezinto uma ke kwenziwa ikhomba.
that's where the trial within a trial has to be conducted to prove the admissibility.
Kula ke icala lelo kukhulunywa ngayo liye limiswe bese kuqale licala ke mayelana nalo khomba ukuthi ngabe lobo bufakazi lobo buyamukeleka na.
That is the line of argument which my learned colleague put before this court.
Yibo izo izethulo ke lezi zithulo ummeli wakho phambi kwalenkulu.
It's like we were doing a trial in a bail application.
Ubukela ngathi besiqula icala esiceleni sebheyili.
He indicated that the SAP 329, the form for identity parade, is flawed.
Utshele inkundla ke ukuthi ke leli form leli ke elisetshenziswa ke uma kwenziwa ikhomba ke lelo form lelo alungile.
And Captain Montwedi indicated to him that he has been using that form for the past 33 years.
Ucaptain Montwedi uyamcacisela ukuthi ke usebenzise lelo form eminyakeni engama-33.
And that is also a matter for trial.
Kanti lokho ke futhi indaba ke lezo ezokhulunywa uma icala liqhubeka.
I believe my learned colleague listened to the difference between the bail proceedings and the trial proceedings.
Ngiyakholelwa ukuthi ummeli wakho ke uzwile ke umehluko phakathi kwesicelo sebheyili noma icala seliqhubeka.
Okay? At this stage, Your Worship, when I go to my learned colleague's case,
Manje ke isithubeni samanje uma ke ubhekisisa ke ecaleni okanye ecaleni elibekwe ummeli wakho enkundleni.
they brought this application through affidavit.
Ngifake ke isicelo sakho ngencwadi efungele.
He continue handing on supplementary affidavits.
Uyaqhubeka futhi usanikezela ngencwadi efungele ke isicelo sakho.
During the bail hearing.
Masiqhubeka ke isicelo sakho sebheyili.
We state, we led viva voce evidence.
Thina abashushisi into esiyenzile sifaka ufakazi ke la sibathula ufakazi.
So we called Captain Montwedi to testify under oath.
Sesabiza uCaptain Montwedi ukuthi azothula ke ufakazi efungile.
Now the court is facing with evidence.
Manje ke inkantolo ibhekane nento ezimbili
Now we have to look at the weight. Which one has got a weight? They didn't call anyone to testify under oath. They handed the affidavits. As we led Viva for Care evidence, state submit to the court that our evidence has got more weight than that of the defense. Coming to the personal circumstances of the accused. State submitted, Worship, the accused has got no fixed address. Even if they handed the evidence through affidavits. At this stage, the utility bills or the rate and taxes, which shows that the accused stays there or he pays the rates and taxes, was not handed to this court as an exhibit. So let's say, for instance, if he doesn't have a property, or perhaps a lease agreement, it was not handed to this court as an exhibit to prove that he stays there. Actually, what was handed to this court to prove where he stays? Initially, it was an affidavit from the so-called Induna, the chief. Later on, they handed in the affidavit, which is from the councillor. From the area which he alleges he stays. Of which I'm of the view that they just went to the councillor just to confirm that he stays there. In my area, the ward councillor doesn't even know myself where I stay. So they handed into affidavit, the first one, which shows that, just for a while, which shows...
Exhibit before court. One is from the investigating officer. That is from the investigating officer, the other one is the council.
I think there was one, Worship, if my memory serves me well, the one which they handed in, which they say that it is from their Indunas, or maybe... As the court places, Worship. There are the
B and C, only two.
As the court places. The address which they mentioned on the affidavit, it says that the accused stays at room 50, block 3, Mirafe Hostel.
room block 3, room 50, hostel.
And the affidavit, which is from the council, it says that the accused stays at room 50, block 3. Just for a while, Mapetla hostel.
Kanti ke incwadi efungelo lethe yekhansela ke ithi yona uhlala room 50 block 3 eMapetla hostel.
So the affidavit from the council and the address which the defense mentioned on the affidavit which they've handed it to the court as an exhibit, they differ.
Kanti ke ikheli ke leli embhale umlezo wekhansela yekhansela kanti ke nale incwadi yakho yesicelo sakho sebheyili lawo makheli omabili ahlukene okanye ahlukile.
So I clarified it from Captain Montwedi. He indicated that there's Merafi hostel, there's also Mapetla hostel.
Ngiyacacisa ke lokho kuCaptain Montwedi ukuthi akacacisele inkundla mayelana nalamakheli akho ke wathi ke uCaptain kune Merafi hostel ubuye ke futhi kube neMapetla hostel.
Hence, I already stated during my argument that we are confused as to where the accused stays at this stage.
Njoba sengicacisile ukuthi thina sididekile ukuthi kahle uhlala
State submitted if the accused has got no family tie.
thina ke abashusisilasho ukuthi yena wona unamndeni.
It was submitted to this court that he has got 12 children.
Kubekiwe la enkundleni ukuthi nengane ezishumi.
But there is no indication whether he stays with these 12 children.
Kodwa kushiwo ngokwenye kucacisile ukuthi ngabe
And furthermore, there is no indication, or they say that he's single.
kuziwa ke futhi maqhubeka ukuthi ke wena ushadile.
So, on the address itself, Worship, the state submittership, the accused is at flight risk.
Ngakho ke masikhuluma ngekheli lilodwa thina ke ithule sizithule enkantolo ukuthi ke wena uma ungakhulumi uzolibaleka.
So, if this court grant him bail, he abscond, we cannot able to trace him.
Uma ngabe ke wena inkundla inikeza ibheli bese ungasabuya enkantolo angeke sikhona ukuthola.
Employment history.
Sikhulume ngokusebenza.
The accused person, Worship, has got no fixed employment.
Wena awusebenzi.
They says that he is self-employed, he owns taxis.
Nithi nina wena uyasebenza unamatekisi umnini wamatekisi.
There is no indication in this court as to which association is he belonging to, the accused, for taxi.
Ukuthi ke njengoba unamatekisi ke wena ukuyiphi association?
Or even the car papers, maybe just to prove that I own these movable assets. Here are the papers of the car. These are, I own these movable assets.
Noma ke amaphepha ke emoto walethwanga ukuthi ke azobonisa qinisekisa ukuthi ngempela wena unalo nalokho.
And therefore, should be state submittership, the accused has got no fixed assets.
Ngakho ke thina isethulo sethu sithi ke wena awunalo.
Just for a while, Worship. Your Worship, in terms of section 35(1)(f) of the Constitution,
Uma sikhuluma section 35(1)(f) yomthethosisekelo.
it says that the accused person can be released from detention if the interest of justice permit.
Ithi ke lo section le wena ungakhululwa ngebheyili uma uhambisana nobulungisa.
subject to a reasonable conditions.
Kanti ke lokho kumele kuhambisane nezizathu ezizwakalayo.
So now I can say that section 35 1F versus section 6011A.
Manje ke ngathi ke singabheka yona le section le kumthethosisekelo bese sibuya ke sibheka nesindeleto section 61. Lapho ke encwadini zomthetho.
Section 6011A is the one for Criminal Procedure Act.
Kanti ke le section 11A enkhuluma ngayo isencwadini zomthetho.
It provides that the accused shall remain in custody unless the accused provides evidence that proves on the balance of probability that there are exceptional circumstances which permits his release on bail.
Ithi ke leyo section leyo wena ke ungahlala ke ngaphakathi ngaphandle kokuthi ke wena ke uma qhathaniswa ke izinto kanye izizathu la enkundleni ngempela kunezathu ezikhethekile ezivunayo ukuthi wena ungakhululwa ngebail.
Section 35 is the right of the accused.
Section 35 ke amalungelo akho njengommangalelwa.
But now here in court, that right, it is limited.
Kanti ke la enkundleni ke lelo lungelo lelo ke fushane.
It is limited by section 6011A
Into ebambayo ke lelo lungelo lelo section 6011A.
and also limited by section 36 of the Constitution.
Futhi ke ibanjwe ke futhi section 36 umthethosisekelo.
And therefore, should be now as we speak, the accused or the applicant has to prove before this court that exceptional circumstances exist that he should be released on bail.
Manje ke njengoba sila enkundleni wena kumele ubonise enkundleni ukuthi phela zikhona izathu ezikhathekile ukuthi wakhululwa ngebail.
So at this stage, your Chief State submit that the applicant didn't adduce such.
Manje kulesithuko esikuso ke sibeka ke isithuko sethu sithi ke awukwenzanga.
I can refer this case, your Chief, to S versus Felyun.
Kanti ke ngaqhathanisa ke lecala leli nangalesikhathi ke kushushiswa ke Felyun.
2002, volume 2,
Icala la isinqumo esathathwa ngo-2002 volume 2.
South African Criminal Law Report,
Kanti ke embikweni ke yamacala
page 550,
kanti ke ekhasini le 503
SCA, Supreme Court of Appeal.
kanti ke lapho lelo cala lalilalelo ke enkantolo yokubukeza kuyekezwa kwamacala.
In this case of S versus Felyun, it was said that it was also confirmed that where a bail applicant
Kanti ke kaqinisekiswa kulesicelo ukuthi ke uma umuntu efaka isicelo sebail
taking into account what was already on record,
abhekisisa okanye anakisisa lokhu ke inkundla enayo
failed to make out a prima facie case for his release,
ukuhlulekile ke lo muntu loyo ukufaka ke ubufakazi obuqinile ke ukuthi uyakhululwa.
there can be no duty on the state to advance evidence in rebuttal.
Akusiyona umsebenzi wabashushisi ukuthi ke bona ke beze nobufakazi ophikisana nalo.
And this is what's happening in this one matter.
Yilokho okwenzakalayo kule cala.
Just for a while, Worship. The accused worship also mentioned that he has got the address in Natal.
Uye wabeka ke la enkundleni ukuthi ke unalo imikheli laseNatal.
There's also no proof of that address.
Kanti ke akunasiqiniseko mayelana nalelo kheli.
Your worship, state submit that in terms of section 60, 4A to E.
Kanti ke masithula izethulo zethu sibheke ke section 16
of the Criminal Procedure Act.
yencwadi zomthetho.
State submit that, Your Worship, if the accused person is released on bail, there is a likelihood that he will interfere with the investigations.
Kanti ke iyacacisa ke ukuthi ke uma ngabe umuntu ekhulelwe ngebheyili kanti kunokwenzeka ukuthi ke phazamise uphelo.
There is a likelihood that he will interfere with the evidence.
Kanti ke kungenzeka yini ukuthi ke uzaphazamisa ubufakazi.
There is a likelihood that he, if he is released on bail, he will endanger the public safety.
Kanti ke kungenzeka yini lo muntu ekhululiwe angafaka ke impilo zomphakathi ngaphandle kwesengozini.
There is a likelihood that he will, if he is released on bail, he will commit a Schedule 1 offense.
Kungenzeka yini ukuthi yenze elinye lamacala sesigabeni sokuqala.
There is a likelihood that if the accused is released on bail, he will abscond, he won't attend court.
Kungenzeka yini uma ekhululiwe ngebheyili ke bese ke angasabuyi enkundleni alibalekele icala.
Just for our worship. Furthermore, Your Worship, in terms of the said section 64A to E of the CPA, if there is a likelihood that the accused will jeopardize the criminal justice system, public order, if he's released on bail.
Ke uma ngabe kuzoyenzeka ukuthi yena uphazamise ukusebenza kobulungiswa noma ke ukuthula emphakathini.
And therefore, I should be at this stage, Worship, I'd like to refer this court worship to just for a while. Just for a while. In the case of S versus Matebula,
Ngalesikhathi kushushiswa ke uMathebula uma eqhathanisa ke nesicelo sakho.
2010, Volume 1.
Ngonyaka ka-2010 volume 1
South African Criminal Law Report.
laphana encwadini ke zokubika ke ngezomthetho.
Page 55, Supreme Court of Appeal.
Kanti ke iphuma lapha esekasini lesi-55 kanti ke iphuma ke isinqumo sithathwe enkantolo yokubuyeka zokwamacala.
It was said that for the accused to prove that exceptional circumstances exist,
Kuthiwe ke wena ke ubonise enkundleni ukuthi ke ngempela izathu ezikhethekile zikhona.
you must be certain that during the trial you'll be acquitted.
Kumele ube nesiqiniseko sokuthi ke uma icala liqulwa wena uyothola icala ngencala.
Of which it is not the case in this one matter.
Kanti ke kunecala akukho kanjalo.
The video footage which my colleague made noise about it.
Lesicofo ke lesi ke uzakwethu ke oba ngumsindo omkhulu naso.
We are not only relying on that footage.
Asigcinanga ke kuleso sicofo.
We have the eyewitness who witnessed the incident.
Sinaye umuntu obonile uma isehlanganiseza la.
We have got circumstantial evidence.
Kanti sinabo ke abanye ufakazi abangabonile kodwa ke kuzoba khona lo ufakazi.
And therefore, Your Worship, state requests the court worship to refuse bail for the accused in the circumstances.
Ngakho ke thina njengamashushisi sithulo sethu esisibeka phambi
The requirements listed in section 11A of the Criminal Procedure Act. Was not satisfied. That's all, Worship.
My reply, Worship. I don't want to overburden the court coming along with this. I sympathize with my colleague, but I'm extremely disappointed with these submissions. So shocking. A house without a foundation is a shack. They don't have a foundation. We have laid a foundation before the court. And a house without a foundation is easily destroyed. What they're doing is like chasing a black cat in the dark or screaming in the sea. No one will hear them. Exceptional circumstances, Worship, are not strictly defined in the Act. Admissions have been made before the court, and they're not going to change it for trial purposes. There is no way. If anything that was said before the court will be changed for trial purposes, then that is tantamount to fraud, perjury, and all of that. Doesn't my colleague know that whatever is said in the bail application will be used for trial purposes? They have admitted to their mistakes with the ID parade and all of that. I don't want to waste more time on this issue. He confidently speaks of their viva voce evidence. Does the viva voce evidence that was presented before the court show as to what role the accused played in this crime? Nothing. My colleague always gets too personal. He's talking of experience. Now let's come to experience. He wants me to prove exceptional circumstances on the personal circumstances of the accused. I will help him. Because when I started, I said these exceptional circumstances are not strictly defined in the Act. So I'll give him exceptional circumstances on the personal circumstances of the accused. The personal circumstances of the accused, he started with the address. This matter, before it was transferred to this court, it appeared before one of the senior magistrates who evidence was presented that address was verified, hence this matter was transferred here. In the presence of the investment officer, they never objected to that. Now wants to come and say the address was not verified.
Manje, le cala le luma cala ukala lona luma waza ke umantu wavela kwamanje lesipilo kanti ke abashushisi bathi ke ikheli lakho leli lihambiyo la njengesisa azange baphikisa ke lo abashushisi ngoba yiba baphela lo maqeda ke icala lakho la dlulisela la enkantolo esebenza ngecelo sebeyi.
This matter moved from one experienced presiding officer to another experienced presiding officer before the court.
Manje isuka kumanje olesipiliyoni iza kumanje olesipiliyoni la kule condition.
The first question this court asked in the court's questions was to say the address that is written in the affidavit of the accused. Is it the very same address where you arrested him? Is it the very same address that you verified? And he said yes.
Uqala ke inkantolo yabuza ukuthi ke lekheli leli elibhalwe la encwadini efanayo yilo lekheli nimthole kumangalelo yilo lelo kheli lelo yaboshelwe impendulo yathi yebo.
The magistrates are not robots, they're human beings, they're very smart, they're objective, they apply the law.
Kanti ke abo magistrate akusona amalobota abantu kanti basebenzisa imqondo yabo basebenzisa umthetho.
Is having 12 children not exceptional enough? He wants me to prove exceptional circumstances on personal circumstances. I'm doing just that now.
Manje ke ufuna ke mina ngibonise ukuthi kunesizathu ekhethekile phakathi kwezizathu zakhe noma ngeza lokho kunabantwana abawu-12.
Is accused of being assaulted. He is limping every day. He comes here. This man who can't even hit a fly, he's here limping every day. Is that not exceptional enough? He seeks medical attention from outside.
Manje ke njengoba ke asithi ke asisizathu esikhethekile wena uma ungena ke la enkundleni ngaso sonke isikhathi uyaqhuba kanti ke wena ke ufuna usizo kodokotela ngaphandle asisizathu esikhethekile ke lesi.
Your Worship, before my Reverend colleague proceed, I was of the view that he is replying my address. But now I didn't mention about anything about the assault. He's adding it. I was of the view that he's limited to, he's replying to what I've addressed to this court. But now it's like he's giving evidence as to what happened in court 23. He's an attorney. He's giving evidence. So he must limit himself to the address which I made.
I'll withdraw that. Fair enough, but it's on record. This accused is injured. Yeah, he is limping. It was even placed on record the first time that he seeks medical attention at prison. Is having an unquestionable alibi, Exhibit E, not exceptional enough? All that my colleague has said was generalization. He goes there and reads. You can't say, but your worship, in this section 60 whatsoever, this accused is generalizing. We honestly cannot waste this court's time. Worship, we are of the view that we have walked through all the corners of the circle to prove to this court that the exceptional on both ends, on the strength of the case and on the personal circumstances. have no further submissions. Thank you so much, Yoship.
Thank you so much.
Yoship, brother, before I sit, in actual fact, I just thought of something. I'll address the court here. I think it's the case of S versus WC and another. It's a 2022 case, subsection 1, SACR 159 GJ. It's 2022 bracket 1.
Is it volume 1?
Volume 1, yes. Or you want to show me your experience? SACR 159 GJ. Apologies, Worship. In this case, certain aspects were highlighted. Courts consider all relevant factors, both individually and cumulatively, to determine if they amount to exceptional circumstances.
Yeah, isinqumo sathatha ukuthi inkantolo menibhekisise ukuthi zonke izinto ezibekiwe la enkantolo zayo ukuthi ke ibhekisise nokuthi lezo ithule nje phambi kwenkantolo ziyizathu ezikhethekile.
And then now it highlights the key elements thereof. It's serious medical condition.
Ukuqala ke ukuthi ngabe udinga usizo kakhulu ke mayelana nempilo yakho.
Unquestionable alibi.
Okwesibili yilo ukuthi ke ungekho kuleso ndawo bekwenzekela isehlakalo.
And witness of the state's case.
Kanti nofakazi ke wabashushisi.
And undue delay in trial. This matter is fairly new. It's got a lot of investigations. The accused cannot remain in custody waiting for investigations, especially for a case that is non-existent. Thank you, Chief. No further submissions.
What's the court places?
Looking at Monday the 26th.
Which date, Yoshi?
26 Monday.
20?
26 Monday.
26.
Yes, you said you're not available. I was noting on what you're saying regarding the date yesterday.
Oh, yeah. I am available on the 22nd. However, if the court decides the 26th, I'm still available on that day. Thank you so much.
Oh, it's for judgment, Your Worship.
Correct.
I just hope my Lelen colleague is done with his address. Because on that day, he might come with a new thing.
I can simply place on record you are done. Bail is an urgent application. We substantiated our application, corroborated our application, what's the state on the other hand.
Umshushisi useyabeka ukuthi uyathemba ngalelo langa ukuthi le inkantolo izakhipha isahlulelo. Angathi ummeli wakho ngalelo langa mamele inkundla izokhipha isahlulelo bese athi kunokunye futhi okushanayo.
Mr. Majola, please stand up.
Ngasukuma baba.
This is postponed to the 26th of January. It will be for court judgment. You are still in custody.
Icala hlaselo ufika nge-26 January khona la enkantolo izokhipha isahlulelo mayelana nesicelo sakho sebheli ngalelo xesha. Namanje uzohlala understood.
Thank you so much. I'm extremely indebted. Thank you so much, Bishop.
Thank you very much to the personality or media personality, and you are also excused.
May I also be excused?
Thank you, Mr. Majola, you are excused.
Thank you.
Mr. Mabuso, thank you very much for assisting.
As the court is, I'm indebted to the court.
Yes.
May I approach the bench?
Or come this side. Come this side.
As the court is.
One that they're going to see this is the club. So, and the one you can go and come back.